Hello everyone, how are you? Welcome to the Databasix webinar R.E.S.P.E.C.T. Find out what it means for privacy. Can I just ask you to type in the text box to see if you can hear me? Okay, so if you could just type yes, that'd be perfect. Awesome. Okay, so just a few reminders. As I'm working from home, like I imagine most of you are, my dog Loki may decide he wants to participate, so you may hear an occasional bark. And the other thing to mention is that this webinar is being recorded and will be available to you afterwards. So if for any reason you need to drop out of the webinar, that is fine. You will get a copy of it. You'll also get an opportunity to ask me any questions at the end. So it should last half an hour and we've got some time afterwards for some questions. So who am I? So my name's Kellie Peters. I am the co-founder of Databasix. I have been working in the field of data and data protection for 20 years. And I'm a little bit passionate about this subject, very much about privacy by design, and hopefully that will come across today. So firstly, I wanted to start off with, did you know? So for a lot of organizations, data protection isn't something that is new. It is something they have been aware of for a significant period of time. Whilst we are now in the world of the General Data Protection Regulation and the Data Protection Act of 2018, in this country, we've had legislation in place for since the 80s, which is what, almost 40 years. The concept of privacy by design is something that has been in place in the previous regulation, but privacy by design and by default became a legal requirement within the GDPR and the Data Protection Act of 2018. So it is in everybody's interest to make sure that we consider privacy and data protection at the very beginning of any new project where it involves processing of personal data, any new system that you are looking to introduce or to roll out to your customer base. So this is about making sure that you understand what we feel are the steps that you need to take to be compliant. And I'm sure you all are. And yes, my dog Loki is very, very aware of all things data protection. So thank you for the comments. So if you have joined one of my webinars before, it will be of no surprise to you that I always like to remind everybody about the basic rules of what the regulation states. So there are, bear in mind, I've consolidated the regulation into one slide. Please don't take this away to say that we're all fully conversant, because it is vastly more complex than this one slide. However, for the purposes of today, I'm going to be focusing on minimization, which is the only process the information that you need to make decisions. That is quite a key requirement when it comes to privacy by design and by default. I'm going to be talking to you about keeping personal data safe and secure, because we will be talking about encryption, safe destruction of data, and making sure that it is fully backed up. We will also very much, and this is at the heart of privacy by design and by default, is the respecting of individual rights, whether they are your staff, your customers, your suppliers, if you're a fundraising organization, your donors and your members. Individual rights are very much at the center of privacy by design and by default. And by applying privacy by design and by default, you are being responsible and adhering to the rules of the regulation and being able to demonstrate that. So without further ado, let's go on and talk to you about what this concept actually is and how it applies to you. So like I said, privacy by design and by default is not new, but it is a legal requirement now within the regulation. So what does it mean to you and your business? Or you may just be observing what is going on in terms of new tech and may want to ask the questions, have they considered privacy by design and by default. And I think one of the most prominent things at the moment that you'll be seeing in the news is the contact tracing apps that globally are being rolled out, and a lot of questions are being asked about privacy. So if you want an example, that is something to look at when we are applying these rules. So the first thing you should really be thinking about on your new processing or your new system that you're going to be introducing that's processing personal data. If it doesn't process any personal data, then, and by personal data, I'm talking about anything that identifies an individual, even directly or indirectly, then the regulation applies. If there is no personal data being processed at all, then data protection doesn't apply in that scenario. So the first thing you need to be thinking about is being proactive and being preventative. So really think about, at the very early stage of your design of your new system or your new idea about collecting new data, is about are there any known security issues with the system or the solution or the processing that you are thinking about introducing. By knowing these early on, what you can actually do is really start to think about the contingency plans or the countermeasures that you're going to be putting in place, or making the decision that you do not want to proceed because it is too risky and could cause harm to the individual. Now, companies typically get financial penalties when there is a significant financial or emotional or physical harm that has been caused to an individual. So we need to make sure we protect the rights and freedoms of all of us. Therefore, if your system is going to cause harm, then it begs the question as whether or not you should be proceeding. And if you are, how are you going to prevent those harms from occurring? So please don't just proceed regardless, because at the end of the day, it will come out and it will get attention and potentially get reported to the commissioner for further investigation. So really think about identifying risks from the outset and putting in measures to prevent those risks. Bear in mind that we can't 100% guarantee that all risks have been removed. So whilst you're thinking about being proactive and being preventative, privacy as the default means that what you are thinking about is the individual at the beginning and thinking about what you actually need to be collecting and why you need to be collecting that. So when I talked about the GDPR rulebook, I talked about minimization. Now, the very first requirement of the regulation is that you must be fair and you must be lawful in your processing. So what you need to consider is what personal data are you collecting? Why are you collecting that information? And what is going to allow you legally to process that information? So is it a matter of consent? Is it a matter of legitimate interest? Will there be a legal contract between you and the individual? Is it something that is a legal requirement? So the government are setting out what needs to be collected and why it needs to be collected. So you need to make sure that you are justifying what you're processing, the purpose, why you're processing that, and making sure that you only collect what is absolutely necessary to be able to make decisions or to be able to provide the necessary systems to your customers and your staff. So always ask yourself when innovating, do you have a lawful basis for processing this personal data? And if you can't, then you are not going to be able to be transparent. You are not going to be able to proceed with the project. So be proactive, be preventative, think about privacy as the default. What we also then need to be thinking about is embedding privacy into the design. So throughout the entire design stage, so if you're working with third-party processors or you're working with a team of people, as a team, you need to be thinking about privacy at every part of policy process. Now, the easy way of being able to build that into your project plan is to have something that is referred to as a data protection impact assessment. Now, this is a massive risk assessment, but what it does is it will sit alongside your project plan and allow you to make sure that you have considered how are you going to communicate with the individuals once the system has gone live. How are you going to explain what data is collected, why it's collected? How is the system going to support individual rights? What are the security risks? Are there any kind of, not only technical risks, but are there any organizational risks that need to be considered from a data protection perspective? Now, the data protection impact assessment takes you through that process and will then sit alongside, like I said, your project plan. So it's quite a nifty document to do. And there's guidance on the Information Commissioner's website on what is a privacy impact assessment. And we've done a previous webinar on it in terms of that talks you through the steps. It's also a great way, and if you remember when I talked about the rules, I talked about demonstrating accountability. A privacy impact assessment is a really great tool to be able to evidence your decision making when it comes to privacy and data protection. Yes, it might feel like it is quite unwieldy or it might be overwhelming, but actually if you are challenged, you've got something that provides individuals and or the commissioner, if it was to come to that, this is what we were thinking and this is what we did when we were introducing or designing this new systems. So it really is about reducing the risk and putting in the necessary controls. Now, full functionality, what do we mean by that? So what we're saying is if you've identified a privacy issue, don't just put it to one side and say, oh, you know what, we'll get to that once we've gone live. Or, you know, that can come as a future update to the system. What you want to be building is a system that covers all the functionality that you've got, but also supports privacy in every aspect. So if you have a non-compliant issue, take it as something. So for example, you have a challenge with your system being able to deleting individuals upon a request for their information to be forgotten. So you've identified that early on. How are you going to rectify that? But then how can you promote that as a really good user benefit to the individuals to say, yes, we support GDPR, and if you want your data deleted, if it's appropriate, here's how our system supports that. So really use the functionality and how you support the regulation as a marketing and sales tool for you. It will help. Now, I think that there is a really good example of where security has been put to one side. So, and I'm not going to bang on about this too much, but a lot of organizations recently have adopted Zoom as their method of which they are going to video conference. Now, the chief executive has gone on record and said that they made ease of use as the core functionality of that system, and they bypassed a lot of security issues. Now, that is a demonstration of how privacy by design and by default was not considered. Because if you knew that there were security issues, they should have been addressed, and you should have found a way of making the system as user-friendly as possible within the confines of it being secure. And that's an example of how it does hit the press, and then how people then make decisions to possibly not use a system anymore. So please think in advance about how you will support that process. So just to recap, we've talked about being proactive and preventative. We've talked about privacy as the default. We've talked about embedding privacy in the design and making sure that your system is fully functional and supports privacy. Now, the next one is the security component. And for me, this is something that is critical to any project that is processing personal data. So we need to be thinking about how we can, from the point that you engage an individual in their data collection to the point that you no longer need that data, How are you going to make sure that from that beginning of, yes, I'm going to give you my information, to the point where you finish that you no longer need it, how are you going to make sure that that information is secure? Now, there are things to consider. Obviously, think about encryption. Is there a genuine possibility that you can encrypt the entire journey of that client's or staff member's data? Think about all the different systems that could be involved in that level of encryption. Think about testing. And you may have also experienced this. There have been many an occasion where people have believed their system has been backed up, and yet when it comes to testing the backup, they found that the backup has routinely found, and that what they found is they've lost significant data. So when you are designing your system, build in the concept about how are you going to build in resilience and contingency, and think about the current situation we're in. Business resilience and contingency are fundamental. So we want to make sure that we can reassure anyone that's using the system that we have protected their data and that it can be restored if for any reason there is any problem with the system or the data processing. Obviously, it's important that we have appropriate access controls, and that is, all the way from a system administrator to the individuals that are accessing systems and processes. So who needs the access? What level of access do they need? And how do you restrict that when that individual has moved away or no longer needs access to the system? How do you know? And how are you going to change the controls? Finally, then, and I think sometimes this is forgotten about, a lot of people I talk to think that data can be kept forever. And one of the principles of the regulation is that you should only keep data for as long as necessary, what is referred to as retention. So when you no longer need the data, how are you going to destroy that, whether it be in electronic form or, shocking, there is still people that use paper, in paper form? So how are you destroying that and genuinely destroying that information so it's removed from the systems? And how are we providing training so people are aware of what is good about the system, how it is used, and what are the security measures? Again, from a marketing perspective, it's a really good tool to be able to let all your staff know this is what the tool is, or the system that you're designing, or the app that you are building. This is the measures that we've put in place. Please tell people about this if they ask questions. So my statement for it, and I do stand by this, without strong security, there really cannot be privacy, and you can't say that you have it is in privacy by design and by default. So it is an important factor. And then the sixth kind of thing I'd want you to think about is really about visibility and transparency. So the regulation requires us to be transparent. It requires us to inform individuals how we are processing their information. So the right to inform is the first right that every individual has. Therefore, you have to tell them. But you not only do you have to tell them, you have to tell them what you're processing, why you're processing it, how you're processing it. Who else is going to be involved in processing their information? So for you to be able to demonstrate your accountability, which is if you remember the grid that I showed you of the icons, is the final one. Make sure that you have contracts in place with any third-party processors. This is key because you want to make sure that throughout the entire chain where the data flows between, that everybody is responsible for that data and understands their responsibility in line with the regulation. And contracts are the ideal way of being able to manage that relationship. You want to be able to demonstrate through your updated privacy policies. Now, for some companies, they updated a privacy policy in May 2018, and they may not have done anything to that privacy notice or privacy policy in 2 years. Now, I would challenge anyone to say that they haven't changed some type of system or process in a 2-year period. So where you are introducing new systems and new processes, don't forget your privacy policies and your privacy notices to make sure that the individual can see that and they can read it and they understand how you're processing their data. So a privacy policy, pretty fundamental when it comes to demonstrating transparency. And then it should be no shock that the final step of the 7 things that I've talked about, this is the final one, is that we absolutely need to respect privacy. And by that I mean is that think privacy first. We need to make sure, and in actual fact, as I say on the slide, the regulation demands that we put individuals at the centre of everything that we do. Now, these are not all the rights that an individual has under the regulation, but these are the ones that I think we need to be mindful of at the moment. So the right to be informed, as I said in the previous slide, individuals have the right to know what you're processing. If you can't tell them, then should you be processing that information? They have the right to access their information. Now, subject access requests are a very useful tool an individual has to be able to say, I want to know what you process on me. Now, if you've done your privacy impact assessment, you'll know all the data that you're processing on them and you'll be able to respond to that request. But you have to be able to know that they have that right, and you have to know that your systems and that your people recognize the request and can respond. And in some cases, depending on what you're relying on as the legal reason for processing their data, they have the right to ask their data to be deleted. So again, if you've identified early on that your system cannot delete data, then you cannot fulfill the individual's right for their data to be deleted or forgotten. So they have the right, your system needs to be able to support that, and your staff need to be aware that this is a genuine right. So it's important that we understand that, but they can actually be a really good advocate. So if they know that you take data protection seriously, you have considered their rights, individuals will promote that. They will talk about good systems, good processes, good apps. And conversely, they will absolutely, all over social media, will tell people about systems and apps and processes or companies that really don't take privacy seriously. There was only last year that there was the Netflix special on Facebook. So they were very massively challenged about what they process, why they process it, who they share it with. So please, please, please respect individuals' privacy. It will work in your favour if you think about their rights first. So that's enough about me going on about that. But why? So I've talked about some examples, but why is it really important? Why should we think about privacy? There's a cost with thinking about privacy. There's an additional burden on having to demonstrate your accountability. And it might be something that you're having to justify with senior managers as to why is this so important? Well, and this might be a slightly old example, but in September 2018, at the Tory Party conference, there was an event app. We've all gone to conferences and I may be generalizing, but I've gone to conferences and I've seen apps. You download it and like, this is a good way of me knowing who's speaking, being able to connect with people. What this app did was it released everybody's email addresses. So all the MPs' private email addresses were released to everybody that had access to that app. Clearly not thinking about privacy by design and by default. And the argument was that harm could have been caused to those MPs because they're high-ranking public individuals and their private contact details have been released. So the importance of thinking privacy is incredibly important. I've said that twice, but please do make sure that it's at the heart of what you do, because it can hit the press, or it could get shown or talked about in terms of your local communities. So what are the tools? So I've told you about the 7 things that you need to be thinking about, but what are the tools that you can have to hand where you can actually make sure that you follow the data protection by design, by default? So this is what I refer to as your toolbox that you will have to hand, that you can pull out the relevant tools to support this within your business. So you must have, and this is me saying you must have, the regulation does require you to have a register of processing activities. This can be, and the Information Commissioner has them on her website, this can be a simple tool that allows you to capture as a business what you process, why you process, so the purpose, how long you hold the information, what's the lawful basis for processing that information, where in the world is that data stored, who do you share that information with, do you have contracts with third parties? So this is kind of like your central document for everything that you do as a business. It informs your privacy notices, so it allows you on your website to demonstrate to individuals, this is how we process information. It allows you to write maybe more specific privacy notices that are app or software specific, that you may feel you want to really drill down on a particular system and what you process. You may want to draw out your privacy impact assessment. So if anyone asks you, did you do a DPIA for your new system or your new app? You can say, yes, here is the impact assessment that we did, and here are the findings, and here's how we integrated that with our project and our development. And obviously from the demonstrating your accountability, it's things such as how are you communicating with your staff, how are you providing them with training on the new tools, the new systems that you're using either in-house or you are building for the external customer base. And again, that allows you to be able to use it as a marketing tool as well. So these are some of the tools that you could draw on to help you demonstrate a privacy by design and by default philosophy. So before I go into a little bit more about us, it's an opportunity now for you to ask me any questions that may have arisen in the last 27 minutes that I've been talking. So please use the chat box if there are any specific questions that you have that you would like me to answer. Obviously, if you'd like an offline call, that's fine. We can arrange that. That's really not a problem. So I can see that people are typing, so I'll let you type your questions to me. So whilst those questions are coming up, I'll just have this slide up. So I hope the session has been useful. Okay. What I would also say is that we have other resources. Well, so I'll come back to the questions as they're being typed at the moment. Okay, so a question I've got is, we have someone that uses a third company for tests. I can delete personal data. How are we expected to deal with documents sent in emails many months ago? I think it comes down to when you are mapping your information and you know what information you've got. So if you've got current customers and you know you've got current customer information in a database, but you've also got it in paper format, or you've got it in email. So where are the different places that you have customer data? So on this slide, I talked about that register of processing activities. So where you know you've got individuals' information in multiple places, it's about coming up with a process that says, actually, we have to keep customer data. Let's have an arbitrary figure of, say, 6 years. You want to make sure that you can store that information somewhere that's easily accessible to you, so that when you reach that retention period, you can delete that. So it's not just from a system, it's from emails, it's from any paper files that you have. So knowing where your data is quite critical for you then being able to really be able to then delete data when it's no longer appropriate. And in terms of the question that the next question I've got is, should we be using links instead of PDFs to send to the end user? I would. I think it's a good example is there's a lot of accountancy practices now that previously sent out pay slips via email, and what they've now done is they've moved to a system where they've given individuals direct access to their information for them to download. So I think if you have the ability to send individuals to a central system where they can control what they download and how they access it, and you've removed the need to email them that information, then I think that's a really good idea, because you've also removed the real risk of emails going to the wrong person. So yes, if you've got the ability to send links rather than actual documents, and you've given the control to the individual about how they access and download that, that's perfect. So in terms of us, so if there are any other questions, please do type them in the chat box. And we do have a podcast. We have a podcast that's now going out every Monday. It's on iTunes and it is on Spotify. We do have had previous webinars that link to this one might be of use to you. So one that we did last month, which was Brave New Online World, which talks about some of the challenges of the fast-moving digital transformation. And we did a webinar last year about how you actually complete a data privacy impact assessment. So I've got another question. So we've got an individual that works in market research. So everything that they do is processing personal data. Yeah. Okay, so you have an issue with non-compliant projects. Yes, so I think for me, I think the good thing is that you are aware that there are issues. So I think it's about being practical. So if you can rank those projects in terms of what of those projects, which is the greatest risk, which is the one that has the highest potential risk to individuals, whether it be emotional or financial, it's probably less likely to be a financial. So rank your projects in terms of risk, and then try and tackle them on the highest priority first down. I think as a processor, your clients as the controllers will expect you to be able to manage their data. If they are sending you their customer data for you to do market research on behalf of, they would expect you to make sure you can demonstrate compliance. But for me, I think it's how can you risk assess those backlog projects, and how can you address the ones that are the most at risk and address them first, because they're the ones that are likely to cause you the most problems. I hope that helped about the non-compliant projects. But if you want to have a conversation, I do work with a number of market research companies, so I'm happy to have an offline conversation. The next question I have, which is a really interesting one, which is about the impact of data protection and Brexit. So for everybody on the webinar and anyone who listens to afterwards, we will still have a data protection regulation in this country. So we will enshrine the EU, EU into a UK GDPR. So we'll have both the UK GDPR plus a Data Protection Act of 2018. The biggest challenge that we're going to have is the fact that we will be seen as a third country. So we'll no longer be protected by the European member states. So where you have customers that are outside of the UK that are sending you data, what you need to be able to demonstrate is how you comply with European data protection laws, you may have to have specific contracts in place between you and your customers that are in European countries about how you comply with the law and how you can demonstrate that, because there will no longer be the free movement of data between the UK and Europe. So it has to be bound by a contract. So there shouldn't be significant amount of change in terms of how we adhere to it. We may have to wait 18 months for the EU to determine whether or not we are a safe place for data to be sent to and be given what is referred to as an adequacy agreement. But we do have a webinar on Brexit. And again, if there are specific questions you have about it, about Brexit and your business, I'm happy to have that conversation with you. So as a wrap up of us, we provide practical advice and guidance. Hopefully I've given you an example of the kind of practical advice that we give. We have a website, so we have webinars, free webinars, blogs. We do, like I said, the podcast. We do offer audits, mapping, policy writing and training. So if any of that feels like it's something that is relevant to you, please do get in touch. We're happy to have a conversation. If any of you would like a specific chat with me about something, either indicate in the text box that you would like an offline chat with me, and I'll make sure that happens. But obviously there is no obligation for that. I hope this webinar has been useful. It has been recorded and will be available on our YouTube channel within a couple of days, and it will also be available on our website. I do hope that you all keep safe and sane. I'd like to thank you for listening to me talk, I hope, with a little bit of passion about the subject of data protection. And I'd be interested if there are any subjects that you would like a future webinar to be on. Please email us info@dbxuk.com or just email me following this webinar. So thank you for your time. Have a great day, and I hope to see you at a future webinar. So thank you and goodbye.